Hello everybody. I am Dr. Anil Sangli, consultant neuro and spine surgeon here, and here with me is Mr. Sripad, who is an advocate. Welcome to MEDICO-LEGAL Dialogues, an advanced episode on consent. This is the episode 3. Informed consent, the contract, the constitution, the codes and the international standards. Sripad, in a previous discussion, we discussed about the informed consent from the medical perspective. We said that consent is not just merely a signature, it's just a process of communication, understanding, trust, and transparency. Now, I want to take this discussion to a higher level. As an advocate, when you look at a medical consent, do you see it only as a hospital form or it is just a consent? I would like you to explain that from the legal perspective.
Thank you, Doctor. And from a legal perspective, I think I never see consent as merely a hospital form. A consent form is a record of a very serious legal understanding between the patient and the doctor or the hospital. It touches contract law, constitutional law, criminal law, consumer law, medical ethics, and international human rights principles as well. At its heart, consent is about one simple legal idea, that is, no one should touch, operate upon, cut, inject, anesthetize, transfuse, or treat my body unless I have agreed after understanding what is proposed. That is why consent is central to medical law. These consent forms, they protect the patient's bodily autonomy. It protects an honest doctor, as I told in the previous episode, who has explained the procedure properly and has documented it carefully. Now, an important aspect of this consent or informed consent under the medico-legal perspective is the Indian Contract Act.
You tell me more about the Indian Contract Act in relation to the consent. Is it just a contract because there is a offer and an acceptance that is given by the offer by the doctor for surgery and acceptance by the relative or the patient, or is it something else more than that?
See, an important basic foundational act that is a core to the medico-legal informed consent is the Indian Contract Act, which has been enacted in 1872 during the British period. Under this, there is one important section, that is section 13, which clearly states what an agreement is and what a contract is. Two or more persons are said to consent when they agree upon the same thing in the same sense. This is the legal principle, what is known as consensus ad idem, which means the meeting of minds.
Yes.
Section 14 of the Indian Contract Act says consent should not only be free, it should not have been caused by coercion, undue influence, fraud, misrepresentation, or mistake. And this act recognizes competence through age of majority, soundness of mind, and legal capacity. So all these conglomerate when an informed consent is entered into between a hospital and a patient. And if the doctor thinks that the patient has agreed to a high risk surgical procedure, for example, and the patient only thinks, doctor will do, he'll do a small procedure and I'll be fine. It means that there is no agreement at all as per the Indian Contract Act, which is the basis.
Why? So what you mean to say is, if there is a person, if the doctor has asked, both of them know there is a surgery going on. But if the doctor says that surgery is major and the patient thinks that surgery is not so much of a major surgery, then there is no meeting of the minds.
And also, the doctor would have explained the risks of the surgery. But the patient or the patient relatives, normally you see in the hospitals, they say the patient will be fine, no doctor, after surgery. So it is not a case where high risk is excluded. But the patient would not have understood the complication of the risks of the surgery. That means that according to the law, there is no consensus ad idem, which means there is no meeting of the minds between the patient and the doctor. Why? Because the doctor would see that from a risk perspective, while the patient is seeing it from, okay, he'll be all right immediately after the
everything should be
surgery.
all right after
So there is no understanding. So if there is no understanding from the Contract Act perspective, we are missing out important aspects, and some of them are competence, information, understanding, voluntariness, specific agreement. These are some of the basics, along with consensus and item, that are very much important for the purpose of informed consent.
So when you talk of this consent not as a contract, then what is the difference between this consent and an ordinary contract?
See, ordinary contract, I'll just take the concept of a commercial contract, that is between the consumers and the service provider. In a commercial contract, there will be two parties normally, or more, and the normal dealings will be with respect to money, property, goods, or services. But medical consent is much more delicate, because it is not concerned with any product. It is concerned with the human body, the health of the person, the risk, the dignity, and sometimes life itself. So there is a lot of difference between a commercial contract or you enter into a rental agreement, which is totally different from a medical consent. In medical consent, there is an imbalance of knowledge. You should understand this. Why? Because the doctor knows the science, the medical science, and the patient depends on the doctor's explanation. And the doctor carries a special duty to explain clearly and honestly. While medical consent is not merely a commercial contract, the principles of Contract Act are very useful even in medical informed consent. Why? Because the consent, as I told you just now, the consent should not only be free, it should be competent. Competent means it should be legally competent, and it should be informed, for which there should be some evidence, and it should be based on the same understanding.
Correct.
So these are important aspects that go into a medical informed consent, which is different from a commercial contract or other forms of contract.
Thank you. From the constitutional perspective, what is the basis of this consent in the Indian constitutional law?
See, one of the important articles under the Constitution that has been granted or bestowed upon by the Indian Constitution is Article 21, which deals with life and personal liberty, which is very, very important, especially in criminal law, because we have to, that is, the courts have to balance between the offense that has been committed, and also it has to look into whether the person is held guilty properly, legally, and then sentenced to some imprisonment or penalty. Why? Because it affects the life and liberty of the person. So life and liberty is the crux of the whole of Article 21, which is a portion that probably encompasses all parts of life. So modern Indian constitution law, that is what we have after the independence, it treats bodily integrity, privacy, dignity, self-determination as part of this Article 21. Life and liberty doesn't mean that a person is alive and he is free to walk on the road or something like that. It encompasses so many things, of which some of which I am quoting is integrity, privacy, etc. And medical treatment directly affects the body. You are dealing with a body. Therefore, a competent adult patient has the right to decide what is done to their body. And this is why courts increasingly, they treat consent not merely as paperwork, but as part of personal liberty and autonomy of the person.
Okay. And what about the criminal? You talked about the criminal law. What about the criminal law perspective in relation to consent?
See, now in place of Indian Penal Code, we have the Bharatiya Nyaya Sanhita 2023. And it contains certain important provisions that deal with consent and good faith, which includes the Good Faith Medical Acts also. Sections in the BNS deal with consent and acts done in good faith for the benefit of people.
Persons.
And there is one certain section, section 26, that contains an illustration of a surgeon performing an operation in good faith with the patient consent. And the act protects all acts of good faith which have been done with consent and for the benefit of the person. So, criminal law recognizes that a doctor may perform a harmful looking act, that is a surgery, like cutting the body during surgery, but it's not an offense if it is done in good faith for the benefit of the patient with valid consent or in a true emergency. But if consent is obtained under fear, which might happen in most of the cases, misconception, intoxication, unsoundness of mind, or without understanding the nature and consequences, the protection becomes weak. And here, the role of the patient's relatives will be much more than that of the doctor, because in most of the cases patients do hide certain aspects like unsoundness of mind or an accident that has happened, and they might pass it off as some other thing so that it would not become a medical legal case or something like that. So all these aspects have to be considered while entering into an informed consent.
Thank you, Sripad. Thank you very much for your patient listening of this episode of Medico-Legal Dialogues. This is episode 3. We would like to come again with respect to this consent in relation to a very important case law which we have already alluded to, that is the Samira Koili case. Many persons have asked for this particular case in detail. So we would like to discuss about this case, so that because it's a precedence, it's a very important landmark decision.
Yeah, it involves both law as well as medicine.
So we would like to discuss about this case in detail in our next episode. Please stay tuned for this. Thank you very much.
Thank you.